Department 27 is back in session. Judge Allf, presiding.
Thanks, everyone. Please be seated. Okay, I'm calling the case of Ruth versus Carter. Please take appearances from your left to right.
Good morning, Your Honor. Jane McElwain for the plaintiff.
Thank you.
Victoria Allen for plaintiff. Good morning, Your Honor. Christian Morris for plaintiff.
Thank you.
Good morning, Your Honor. Liane Wakayama and Jill Hayes, appearing on behalf of the defendant, Nickolas Carter, who's present at counsel's table.
Thank you.
Morning, Judge.
Okay. All right, so are the media issues resolved to everyone's satisfaction?
We're fine, Judge.
I believe so, Your Honor.
I don't believe we had any that I was aware of, so they'd be resolved on part of the
All
plaintiff.
right, and I'll ask for anyone who's on the phone to please stay muted. We have anonymous that is not muted. Anyone else who's not muted, please do so now.
Oh, and Your Honor, just for the record, my co-counsel, Michael Holtz, is also appearing via Zoom. He's proactive in this case.
Thank you.
Thank
All
you.
right, so, Ms. Morris, it's your motion to dismiss the counterclaim.
Thank you, Your Honor. I think you're basically on what is the quintessential SLAPP counterclaim. And in Nevada, our anti-SLAPP laws are strong. They are some of the strongest in the country. When we bring an anti-SLAPP to this counterclaim that's been filed, we have to show that it's a good faith communication that's made in connection with an interest of public concern. And in this case, we have evidence of a good faith communication based on the personal experiences and knowledge of Ruth Shea. The interesting issue in this case is that we have an issue of public concern, but self-admitted by the defendant, he is a public figure. And as a public figure, as he has claimed in the pleadings in this case, an American icon, that the burden then shifts, once we have said these two things, over to the defendant to show that they have a preponderance of winning on the claims they've made in their counterclaim. But because he is a public figure, they have to show that the statements were made, they were one, false, and true, that they were made with malice, which means an intent or ill will, made with hatred. Now, there have been hundreds of documents that have been filed by the defendant in this case. Once we have made our anti-SLAPP motion, the burden shifts to them. But something that the court needs to be considering of, because this is another strong law that we have in Nevada, is the absolute litigation privilege. So everything that's contained in the complaint and anything that is pertinent to the issues in the complaint in Nevada falls under the absolute litigation privilege. So statements that were made that were related to what's in the complaint, posts that were made that's related to the complaint, and there's two cases that are really on point. Both of them are Nevada Supreme Court cases, but the Fink case talks about the scope in Nevada of the absolute privilege, which is very broad. The defamatory communication need not be strictly relevant to any issue involved in their proposed or pending litigation. It only needs to be in some way pertinent to the subject of the controversy. And so it's really a twofold analysis. There's the anti-SLAPP motion, but in order for them to say that, hey, we have a preponderance of ability to prevail, they have to show that they can defeat the absolute litigation privilege that we have here in Nevada, meaning that these statements are outside of the absolute litigation privilege. And that is a question for the court. That is a question of law. Because if these statements, all of them which are clearly contained in the complaint, and anything that was pertinent to the issues of the complaint, such as the police report, those are quasi-judicial. Those are also protected under the absolute litigation privilege. That's a question for your honor to determine. Because if it falls within the absolute litigation privilege, they have no ability to prevail by a preponderance with all of the documents that they brought. But more importantly, because they have to show actual malice, I ask the court to listen carefully as to what their evidence is, because all of the statements they've made about Shea have talked about her being vulnerable, highly impressionable, craving attention, desperate to fit in. Other parties who are not yet in this litigation I'll represent to you, I've been in contact with their counsel and they will be filing anti-SLAPP motions as well for these conspiracy theories, that she was groomed and coached. None of that shows actual malice on the part of our plaintiff, and we obviously have other facts with other parties. I offered with counsel to move this hearing out until they're here, since there's other conspiracy theories. They wanted this for today, which I 100% appreciate. But I think the issue that is to be looked at is this a good faith communication in furtherance of an issue of public concern? We have that. We also have a public figure, which applies actual malice. But does any of their evidence actually defeat the absolute litigation privilege that we have here in Nevada.
Thank
Thank you.
Thank you, Your Honor.
you. Please.
I want to make sure that we're clear today, listening to counsel's argument, that we're here on an anti-SLAPP. And a SLAPP suit, as Your Honor is well versed in, is a meritless lawsuit that a party initiates to chill another party's exercise of their First Amendment free speech rights. That's not the case here. There is nothing meritless about Mr. Carter's counterclaims, which is backed by an overwhelming amount of evidence. This is not a situation where Mr. Carter sued the plaintiff to silence her. Instead, he was forced to respond to and defend against heinous allegations. And he did so. He did so with detailed facts, with documented evidence, with sworn testimony from a number of witnesses that all support his claims that he has been the target of an ongoing conspiracy aimed to defame and publicly humiliate and extort him. Today, the plaintiff seeks to dismiss his counterclaims in hopes of burying the truth. But as Your Honor knows, everybody deserves their day in court. Everybody has the right to defend themselves, and that doesn't make him a bully. It makes him an involuntary defendant and now a litigant. If he was a bully, he would have filed his own defamation lawsuit years ago. He didn't do that. He took the high road and quietly endured years of online harassment. So now, when he gets sued, he's left with no choice but to come forward. To prove, I might add, a negative of something that allegedly happened 22 years ago. He takes these accusations and these proceedings very seriously, and so does his wife and his family who's here today. Now, our anti-SLAPP statutes are very clear. They posit a two-prong analysis. The first prong concerns the plaintiff's burden. Has she established by a preponderance of the evidence, not us, has she established by a preponderance of the evidence that the statements which the counterclaims are based upon constitute a good faith communication in connection with an issue of public concern? We don't dispute the issue of public concern, but we do have major concerns about the second part, whether the communications were truthful or made without falsity or knowledge of falsity. This, the plaintiff simply cannot satisfy, and frankly, Your Honor, she hasn't even tried. We haven't alleged statements in the complaint or the police report, as counsel's argued, are part of our counterclaims. As a threshold matter, she hasn't addressed any of the communications that form the basis of the counterclaims, which we categorize in 4 different parts in our opposition. And next, which is the most troubling, is that she only relies on her affidavit, filed as an errata, as we were here in front of Your Honor last time, that contains a single sentence that serves to verify her complaint as true and correct. But Your Honor, this court only needs to look at the plaintiff's own documented admissions that directly contradict her verification under oath. On September 21st, 2019, Exhibit 3, she didn't claim she was a Nick Carter victim. On October 20th, 2019, Exhibit 38, she confides in Heather Hyatt that Nick Carter did not sexually assault her, and he only said, quote, really mean things and bullied her. Then you have her December 14, 2019 Tacoma police report where she tells law enforcement that Nick Carter, quote, only grabbed her arm and no other physical activity occurred. As this court is aware, making false police reports is a crime. So were you lying to the police then, or are you telling the truth now? The point for today's hearing is that even prior to this lawsuit, by her own documented admissions, her reports to law enforcement, all of which is evidence in her possession and her counsel's possession, she knew that the allegations contained in her complaint were false when she made them. That's why her reliance on the Williams decision is completely misplaced, because in the Williams decision, there was no evidence in the record to show that Williams' opinion statements that she knew they were false, unlike here. In every single case analyzing whether the movement has met their initial burden, our Nevada Supreme Court has repeatedly held a simple affidavit is insufficient if there is contradictory evidence in the record. Here we have her admissions, we have the police reports, we have our counterclaim quoting actual social media posts and other documentation, and on top of all that, we have our opposition containing 61 exhibits, 15 of which were affidavits, most of which say that her allegations are factually impossible. So she just relies, even with all of that, she just relies on her affidavit and she says that's supported by the Stark case. Well, the Stark case, there was zero contradictory evidence in the record. That's what the Nevada Supreme Court found, unlike the mountain of evidence we have here. So she's failed to meet her burden. So what does she try to do? She tries to skirt around her burden and says, well, an attorney's certification under Rule 11, that constitutes evidence. I'll give him that, Judge. It's a creative argument, okay? And we do hope they satisfy their Rule 11 obligations and they continue to do so. But there is no legal authority provided to this court that Rule 11 supplants the evidentiary burden under NRS 141.660. Our anti-SLAPP statutes, they require actual evidence. Otherwise, if you think about it, if this plays out, does that mean I get to depose her attorneys and ask them, what evidence did you review in good faith before bringing this lawsuit? It doesn't work that way. So the actual record before this court shows that the plaintiff has failed to meet her burden, and it's our position that the inquiry ends there and her motion should be denied. However, if the court finds that the burden shifts to Mr. Carter under the second prong, he is more than satisfied it. The test is minimal merit. Not only does Mr. Carter's counterclaims have minimal merit, but substantial merit. They don't oppose the fact that he has shown a probability of prevailing on all of his counterclaims with prima facie evidence. She says that, counsel says, well, they have to prove falsity and malice. The court's not weighing the evidence today. That only goes to the defamation claim. So instead, her only argument is this absolute litigation privilege. The problem is that none of her statements fall under the scope of that privilege. As Your Honor is well versed, for over 20 years, the FAPE case, the Nevada Supreme Court has held that the scope of the absolute privilege is broad, but it has limits. So in order to be cloaked with this privilege, the statement must be made to someone who is significantly interested in the proceeding, who the Nevada Supreme Court defines as someone who has a legal or a financial interest. So Twitter, podcast listeners, the media, the internet as a whole, they do not qualify as an interested person. And in fact, the Nevada Supreme Court has held that statements to the media are not privileged, period. That's the Jacobs v. Adelson case. The court expressly rejected arguments that says, well, just because a celebrity is involved, the attorneys are free to litigate their case in the press. Not true. So the staged press conference, the promotional media announcements that form the basis of our defamation claim, they fall outside the scope. The other problem, Your Honor, is that the plaintiff's claims to have made these statements where litigation was contemplated in good faith and under serious consideration, Your Honor, we submit that is legally impossible as a matter of law. Her statements began in the fall of 2019, well before Senate Bill 203 was even introduced to our Senate, let alone signed by our governor on June 2nd, 2021. So how could she seriously be considering litigation when her claims were time-barred long before then? Plus, these statements occurred 12 to 24 months before this lawsuit was filed. So that would mean a party could continuously defame someone, and then claim the privilege years down the road just because they filed a lawsuit. Allowing that would run afoul of every public policy that underlies that privilege. And it would create actually a very dangerous scenario where the privilege is construed as granting a license to defame with no limits. So, Your Honor, we submit that the plaintiff has failed to meet her burden based on the actual record before you, And we ask that you deny her motion on those grounds and find her motion to be vexatious and frivolous and enter a cost award in favor of Mr. Carter. But even if you find that she satisfied her burden despite what the actual record is with contradictory evidence in her loan affidavit, we ask that you find that Mr. Carter has met the minimal merit requirement and her motion should be denied accordingly. Thank you.
Please.
Yes, briefly, Your Honor. Under Rule 11, every pleading, written motion, or other paper must be signed by at least one attorney of record or the attorney's name. Obviously, the complaint was signed by us under our obligations under Rule 11. To ensure that the defendant was clear that these were the facts known to Shannon Ruth or Ruth Shea, is the allegations in the complaint in this action are true and correct to my own knowledge and experience, and signed with an affidavit. To not only confirm what we had put in writing and signed under Rule 11, the affidavit was provided. We have clearly met the prongs, that this was truthful to her own knowledge and that it has to be actual malice. There was a lot that was said by the defendant, but this is a serious allegation counterclaim. And under our laws, we need to have a free and informed public. This is intimidation tactics, asking for millions of dollars. And today was their day to produce evidence that falls outside the absolute litigation privilege that would show that they would prevail, that she had actual malice in making statements that fall outside of it. Because the claims are not addressed at all. There's conspiracy, intentional interference with economic advantage, intentional interference with contractual relations, defamation, and abuse of process. That's the claims that they brought. And once we met our burden, the burden shifts to them. And not one piece of evidence was shown that she made any statement with actual knowledge. They put in affidavits from people saying, well, we didn't think there was a line there. That's absence of evidence. I don't have any knowledge that this happened. That's absence of evidence. And so none of the allegations in the complaint said, hey, when she posted something on social media 2 years ago, we think that potentially falls outside the absolute litigation privilege, and that's what caused me to lose all this money. They haven't made that. They're basing it on the complaint itself, which is protected by the absolute litigation privilege, and anything that's pertinent or relevant to it. But our law is so strong, it talks about even if the statements are made maliciously, if it's made within the context of the absolute litigation privilege, it's protected. And the reason why that is because the policy underlying the privilege is that certain situations, the public interest in having people speak freely outweighs the risk of individuals will occasionally abuse the privilege by making false or malicious statements. Not that that has happened in this case by the plaintiff at all, but that's how strong the protection is. And so we fully met our burden. We have this statement made in good faith against a public figure. And today was their day to bring the evidence. They have to show by a preponderance that they will prevail. They did not bring one piece of evidence to show that she acted with actual malice in making this statement. And that's what they have to prove. And then they have to prove that any statement would fall outside the absolute litigation privilege, which they have not. They have actually made allegations to the opposite. They have made allegations that she was in some way coerced, that she was groomed. Actually the opposite of what their burden is. And so that's why there's a complete absence in what they had to do today, which was to bring evidence to show they would prevail. Thank you.
Thank you, Bob. This is a matter submitted. This is the ruling of the court. There were two grounds sought for the plaintiff's motion to dismiss the counterclaim. One was NRCP 12b-5. The other is NRS 41-635-670. With regard to the 12b-5 motion, the motion will be denied to dismiss the counterclaim. The counterclaim was adequately pled under Nevada law, and all of the causes of action exist under Nevada law. With regard to NRS 41.635, it will also be denied. The counterclaim itself was very detailed. It's a compulsory counterclaim. And the rulings that I'm making here are not binding in any way on the case. They relate only to this motion. But I don't find that the counterclaim was brought to harass or intimidate. And I find that the defendant responded to the motion with an opposition and exhibits that made prima facie case to support his claims. So for those reasons, the motion will be denied, but there will be no grant of attorney's fees or costs. I do find that the plaintiff brought the motion in good faith and under Rule 11.
Thank you, Your Honor.
Thank you,
We'll
Judge.
prepare the order and run it by counsel.
Ms. Wakayama prepared the order, Ms. Morris, to approve the form of the simple order. If you can't agree as to the form, just let me know through the law clerk, and we'll take it from there.
Your Honor, I appreciate it. Just one housekeeping matter. We, at the same time, when we filed our opposition, we know it was rather lengthy. We had filed a ex parte application to exceed the page limit. I do have an order. I know that
Has
was,
that not been,
no, so I do have the order if I may approach to provide that and then.
We submitted it yesterday as well, Your Honor, but
you know, I have an order inbox, so let me see if it's in the box. Where did you submit it?
we emailed it to Your Honor to your JA.
It's already in my order inbox.
Oh, perfect.
I'll turn it around, it'll get filed faster that way.
Thank you, Your Honor. We appreciate it.
Thank you, Your Honor.
I have a question of clarification, just for the purpose of the order. In denying the anti-SLAPP, is it based on the evidence that was produced by plaintiff and not rather the failure to meet our burden of showing it was a communication in good faith and that it was an issue of public concern or a public figure?
It's really both.
So I think for clarification in the order, for the issues in the event that there's appeals, the Rule 11, signing the complaint and her affidavit, was that sufficient in Your Honor's opinion?
I've already ruled that it was compliant with Rule 11.
Perfect, I just wanted
Okay.
clarification on that.
That was part of my ruling.
Perfect, thank you, Your Honor, I appreciate
All
it.
right, anything else?
Thank you, Your Honor.
Thanks, Judge.
All right, everybody stay safe and healthy until I see you next.
Thank you.